Newshour at 9. Co-presented by RP Sanjeev Goenka Group. Driven by Hyundai Kona Electric. Co-powered by JK Tyre.
Good evening, ladies and gentlemen. The Gyanvapi case has put the spotlight back on the contentious Places of Worship Act of 1991, a law that puts a cut-off date to reclaim Hindu places of worship. To be specific, this 1991 legislation prohibits conversion of any place of worship and provides for the maintenance of the religious character of any place of worship as it existed on the 15th day of August 1947. The legislation has been challenged on the ground that it bars judicial review, which is a basic feature of the Constitution, and imposes an arbitrary and irrational retrospective cutoff date, and abridges the right to religion of Hindus, Jains, Buddhists, and other religions. But the centre's lawyer has revealed his own thoughts on the 1991 law. When asked by a bench headed by Chief Justice of India, U.U. Lalit, whether he thinks that the 1991 Act was covered in the Ayodhya judgment that came just 3 years ago, Solicitor General Tushar Mehta said it was not covered, hinting that the verdict, Ayodhya verdict, didn't quite uphold the validity of the Places of Worship Act. Ladies and gentlemen, you would remember that while delivering the Ayodhya verdict in 2019, the Supreme Court referred to the Places of Worship Act and said that it manifests the secular values of the Constitution and strictly prohibits retrogression. The Hindus say that Kashi and Mathura must be exempted from the Places of Worship Act. Listen in.
Findings and the judgment so far as the Places of Worship Act is concerned in Ram Mandir case is an arbiter finding, and that has no bearing value, and that's not a judgment in REM, and it's not a binding precedent so far as the finding on Places of Worship Act is concerned.
Since they made one exception, that is Ram Janmabhoomi, they can make 2 more exceptions. And after that, there can be no more exceptions, because all 3, Ram Janmabhoomi, Krishna Janmabhoomi, and Kashi Vishwanath, were actually where it is a site-specific temples were there.
सॉलिसिटर जनरल से पूछा था कि आप इस कानून के बारे में आपका क्या कहना है, क्या ये राम मंदिर में कवर होता है? सॉलिसिटर ने कहा कि राम मंदिर में कवर नहीं होता है. हमारा ये कहना है कि इस पे सुनवाई डे टू डे होनी चाहिए.
But the opposition sees a communal plot in the reopening of this case. Listen in to the objections.
It is digging crime of the past for the present's utilization. Now, because of BJP want to create an that communal fashion, communal division, and create an anti-minority hatred in the country. Hate is the order of the day now. To establish this new policy of RSS and BJP of running the states, they want to whip up these things. I think this is very bad.
So that brings me to the legitimate question we are asking on the Newshour tonight. The question really is, has the centre dropped a massive hint about its position on the Places of Worship Act, and does it indicate a clear path for Kashi and Mathura? That's the question we're asking on the Newshour. Hashtag Hindu Rights Matter. That's the hashtag and the debate on the other side.
You're watching the Newshour at 9. Debate number 1 on Times Now. Super Prime Time.
Joining me tonight, Ishkaran Bhandari, advocate. Also with me, Subhrashta ji, author and anchor of The Churn. Also joining me, Sushil Pandit, Kashmiri activist. With me, Majid Haidri, activist, Atikur Rahman, Islamic scholar, Tehseen Poonawalla, political analyst. But my first question goes to senior advocate joining me on the show tonight, Mr. Sanjay Hegde. Mr. Sanjay Hegde, I want to get your sense. Where do you think you stand on the issue of the Places of Worship Act? Because it's a contentious issue which has been raised yet again, and it talks about the context of raising this entire issue, which is the Places of Worship Act, which questions have been raised about how could it be retrograde and look at 1947 August 15th as a cutoff date, when along with the Ram Janmabhoomi, it was the Krishna Janmabhoomi as well as the Kashi, the Shankar temple there, that was being contested by the Hindus. And Subramaniam Swamy and people like him have been saying that if you made an exception in one case, make two more and then end the story. Is there a point there?
No, the question is who is to make the exception? Why do you want courts to do the dirty work for you? If one parliament passed a law, another parliament can pass another law. Today, there is a government with a majority in parliament. What prevents this government from passing a law in parliament? You drop the act altogether, change the act altogether, and the government of the day did not even file an affidavit in today's matter. It was when they did not file an affidavit that the court asked the Solicitor General for his personal opinion. Look, we have said it in the Ayodhya judgment that, the Places of Worship Act is an affirmation of the solemn duty which was cast upon the state to preserve and protect the equality of all faiths as an essential constitutional value, a norm which has the status of being a basic feature of the Constitution. It imposes a non-derogable obligation towards enforcing a commitment to secularism under the Constitution. It preserves non-retrogression as an essential feature of our secular values. This is what the Ayodhya judgment held. Now, maybe it was part of the judgment, maybe it was obiter, but an obiter is also binding on smaller benches of the Supreme Court.
No.
You can get rid of this, just one. Let me reiterate the point. You can get rid of all this court proceedings by just passing an act in parliament. Why don't you do it?
All right. But the other point of view can be that the judgment in the Ayodhya matter was a separate judgment. It was not related to the Places of Worship Act. Also, the Supreme Court precedents also show that observation made that are not necessarily relevant to the immediate issue at hand are not binding. Because the debate or the hearing hasn't concentrated on the pros and cons of that particular judgment. It was related to another matter, so not enough attention has been paid possibly to the Places of Worship Act.
So the point is, lawmaking is Parliament's domain. Interpretation of the law lies with the courts.
Okay, so isn't this an issue of interpretation then? Isn't this an issue of interpretation then? Because the Ayodhya verdict was not about the Places of Worship. Ayodhya verdict was different from the Places of Worship Act. So then if you say it's binding and it was said in the Ayodhya judgment, then it's a matter of interpretation.
Even the obiter of 5 judges, and that was a unanimous judgment, is binding on smaller benches. If you want to say that it is obiter not binding, you need a larger bench of 7. But instead of getting through all these legal gymnastics, the simpler route is to amend it in Parliament. And you have the power to do it. Do it.
Well, so Ishkaran Bhandari, is the issue of which is the simpler step? And therefore, should the government use that? Or is this the issue of interpretation of the law as it exists today?
let us put it what the step is all about. Of course, Parliament has its own powers, everybody knows, but equally a citizen in this country has the fundamental right to go to the Supreme Court to enforce his or her fundamental right. So let us not try to exclude the power of the court to constitutionally examine a law. Second point, let us be very clear, exclusion of judicial review, which is being done in this case under the garb of secularism, is the very thing every other person would object normally if any other law did that. And that debate has been long settled that you will not exclude judicial review. Let us come to the third part, which is very important, and which is this. What does this law do in effect? This law in effect says you could have a title, you could have the evidence, you could have all the documents, but under the garb of secularism. In fact, I think it will not be an exaggeration to say this law makes Hindus second-class citizens in their own country, that they will not, even if they have title, facts, evidence, be able to approach a court of law, because Parliament, for certain considerations, certain vote bank considerations, if I may say so, deems that we will deny you access to court. So all this act says, or all the challenges say, is that this act, if it goes, what will happen? People will have access to justice. They may win, they may not win. The courts, the title suits may come to a conclusion that you do not have a title. They may come to a conclusion that you do not have a case which will proceed. They may come to a conclusion that you don't have evidence. So why are we so determined to exclude evidence? Why are we so determined not to have cases go on, which is the logical, rational expectation in any democracy? And lastly, I would only say this much. When a dispute is not directly before the Honorable Supreme Court, Ram Janambhoomi had a clear-cut exception in it, then it was an obiter, and that obiter is not binding. The challenge, that is why notice has been issued, and I think that obiter will not be binding on the court. They may come to a decision that they uphold the constitutional validity. They may come to a decision it is not constitutionally valid, but the obiter will not come in way as per me.
Well, so let me ask Tehseen Poonawalla. Tehseen Poonawalla, the basic issue here, without getting into legalese, is why should one community not have access to the courts to interpret their rights? It's just a question of rights. Today it is the Hindus, tomorrow it could have been some other community, and you know, they would say, I have a problem, but this law that came in 1991 was enforced without a debate in Parliament and had a cut-off date of 15th of August 1947. I just want to ask you, do people of this country who have an objection to this not have the right to go to a court?
There are 2 points out here that I would like to make. Number one, that
of course, everyone has a right to go to court, in this case under Article 32, and seek recourse, legal recourse. However, the respondent in this case, the central government, has not responded, has not put an affidavit down. It doesn't matter what Tushar Mehta ji says orally in the court. What matters is what is on affidavit, and the central government is running with the hare, hunting with the hound. Now, let me answer your question specifically, which Sanjay tried to answer, but let me get a little bit more into details. I take objection to 2 words. One community is being cheated. I will come to that in the second part. But in your introduction, you said an arbitrary date of 15th August 1947 has been put in this petition before the most honorable Supreme Court of India. 15th August 1947 is not an arbitrary date. It is the date India got independence. It is the date we became a democracy. It is the date we celebrate our independence. Therefore, Parliament in its wisdom, with or without a debate, as is your allegations or the allegations of the petitioner, Parliament in its wisdom thought 15th August 1947 should be the right cut-off date to end all past disputes except Ram Janambhoomi issue. Now, to come to the next point of the argument that you are making. In my interpretation of the Ayodhya verdict that was put up by the Honorable Supreme Court and the 5 judges, the POW Act 1991 has been held akin to the basic structure of the Constitution. So Sanjay Hegde is right. This will have to go to a 7-judge or a higher constitutional bench. Now, Ishkaran is right. Let it go before it. We'll see what the outcome is. But you can be pregnant or not pregnant. You cannot be half pregnant. Therefore, the union government has to put an affidavit or remove it in Parliament. You cannot have half a stand of the union government saying we want to remove the act orally to Tushar Mehta, but not act in Parliament or in the Supreme Court. That cannot happen. You'll have to take one stand.
Well,
Yes.
that is a fair point. And Subrashta ji, the government will have to take a position, and 31st October is by when the government has to take a position and file their affidavit in the court. But is this only about that limited fact? Is this only about one community? Because there are Muslims and non-Hindus who have their places of worship which have been destroyed or converted before August 15, 1947. So just by making this a Hindu law or a law desired by one community, are we limiting the import of this law? Because if it is revisited, it gives rights to others as well.
Yes, Navika ji, I would have taken your argument if the Hindus or the dominant group of Hindus would have been advocating for righting the wrongs of history, lock, stock and barrel in a very comprehensive situation. But I don't think that's the case. It's a very specific civilizational question with regards to three temples. Ayodhya, which has been settled, it's Kashi and Mathura now. I think these are the only three temples with which lot of civilizational pride, value, has been ascribed to. And I think the Hindu community has very, in a very articulate fashion, has stuck to this point of view. So I don't think this really opens, a Pandora's box, as you would, as you would claim. Now, with respect to the Places of Worship Act, I think a very important point to note is that places of worship are different from places of prayer. What the whole interpretation right now is with regards to places of worship. Now, with respect to the Hindu community, let me tell you, we cannot pray just anywhere. There are specific places of worship that we go to. Whereas in other communities, you can pray just anywhere, which is fine. I mean, so I think this becomes extremely important, and I agree with you. I think the government should take a position. I think places of worship, the word worship and prayer, they should be delineated. The constitution should absolutely define what worship means. How is it different from prayer? And I think it will settle a lot of questions and a lot of confusion that has been there with respect to this act and with respect to a lot of other issues.
Well said on that. Let me get in Mr. Atikur Rahman. Atikur Rahman Saab, Subrashta, I think, puts it very beautifully. She says this is not about all places of worship. There can be temples in hundreds of other places. She talks about only three which have a civilizational value for Hindus. And they, after the sorting out of the Ayodhya issue, now there are two other issues, which is Kashi and Mathura. So she says that this is a limited fact. This is a civilizational, cultural as well as religious importance issue for the Hindus. It's not about reopening a Pandora's box. And therefore, there should be enough seriousness with which this demand, you can say, or desire of the Hindu community should be looked at from a constitutional and legal perspective, as well as from a civilizational and citizen right perspective. So, Atikur Rahman, I want to ask you, did the people who made the law in 1991 use a fake umbrella of secularism? Because what is secular to others is possibly not secular to the Hindus. And is this now an outdated definition that we are seeing being addressed through the courts at this point?
Well, Navika ji, so the beauty of the argument is, are we witnessing the Hindu awakening or the Hindutva awakening? The bigotry which was committed in the 16th century in the absence of a constitution and a human rights charter, the same bigotry is being committed by the Hindutva awakening in the 21st century in the presence of the Constitution of India. With all the human rights, and the hashtag becomes on times now, the hashtag is Hindu rights matter. Look at the contradictory, this thing. From where to where we are becoming. 16th century bigotry getting repeated in the 21st century in the presence of a constitution of India. Second important point is the people of India, Navika ji, are eagerly awakening the formidable presence of the Modi government, changing, amending this aspect of 1991, insecular, unsecular, whatever you might call it, change it, amend it. Please live and let live. Let the people of India have a scientific temperament. What is the guarantee? Beyond it, after Kashi and Mathura, Subhash ji, beyond it, there won't be any Hindutva awakening.
आपको दिक्कत किस बात से है?
Don't shout.
People, people are going through the legal route. People are going to courts through the legal route. So why are you saying that this is Hindutva awakening, or is keeping quiet about their own rights something that is not allowed in this country? Where is this objection coming from? Coming to you, Subrashra ji, Ishkaran raised his hand first, then to you, and then I'll get in Sushil Pandit.
Ji, the very basic, let us be very clear. What is being said? Bigotry was done in 16th century, bigotry is being done now. If bigotry was done, justice is being done now. Let us be clear on the concepts. Secondly, where does it stop? There is an old legal maxim, fiat justica raut caelum. Let justice be done though heavens may fall. Not to do justice will be continuing of the 16th century bigotry, which tried to enslave a civilization, and setting it right is the basic need of the civilization to do in 21st century to set all disputes at rest.
Historical wrongs cannot be corrected in this ugly fashion, sir. Historical wrongs.
Is not ugly fashion. Going to court is not ugly fashion. Ugly fashion is barbarians invading, plundering, breaking, and using them to create footsteps, breaking idols, carrying them off. That was what was bigotry. What is being done, even though it's a majority community, it is only going to court to say, please and please allow our prayer of us being able to pray at our holiest sites. If you have a problem with that, then that is your problem. But Bharat needs that, and Bharat shall have it.
Well, Subrashra ji, let me read out a statement made by Mr. Mani Shankar Iyer on the floor of the Parliament. This was in 1991. He says, Mr. Chairman, sir, Uma Bharti ji told us when she had visited Varanasi and saw a temple and a mosque together, a feeling came to her that the temple had been demolished. She considered it to be a disgrace to Hinduism. According to her, a Muslim king had built a mosque here. There is only one difference between her and myself. To what she thinks a sign of servility, I take that thing as a symbol of secularism. Don't you think this really defines the politics that has ensued on this entire issue?
Navika ji, there were 4 points made on your show, and I think it needs a befitting response, because Atikur ji tried to spread false and fake information right here on a national channel. First of all, I don't think the government, this was Mr. Hegde's prime contention, that the government has really not taken a position. So what Mr. Atikur Rahman says is that the government is trying to amend the 1991 Act by perhaps bringing in a legislation. That is not the case, Mr. Atikur Rahman. The court has directed the government to take a position and explain its position by October 31. So that was fake news deliberately that was being spread by you. Point number 2, when you make this false equivalence of what happened in 16th century and today, do you even have a sense of what you are saying? How many Hindus have you seen barge into a mosque and say that this is a place of worship? With respect to a civilizational question like Kashi and like Mathura also, Hindus have been patiently waiting. We have been very quiet, and we will be quiet, and we will fight a lone legal battle if that may be, and that has been done and proven in case of Ayodhya. We never tried to demolish any structure in order to, present our point of view. So please take your words back. You cannot compare the barbarity of 16th century with what is happening today. Yes, there is advocacy going on, and advocacy will be loud, will be vociferous, will be articulate. Raise your arguments, raise the quality of your arguments, not your voice, Atikur Rahman. And stop spreading misinformation.
No temple was demolished. No
Yeah, so
temple
Ayodhya
was
is settled.
demolished.
So please
Ayodhya
don't, let's
judgment
not
by
go
the
back
Supreme
there.
Court. No
Ayodhya
temple
is
was
settled
demolished to build a
by the
mosque.
very courts for whom, with whom you have a lot, under whom you have a lot of.
So you are proved wrong.
You perhaps you repose a lot of faith. So Ayodhya is settled. What are you trying to say? Are you trying to say that what happened in Ayodhya? Are you trying to say that Ram Janmabhoomi is invalid now?
Kindly refresh your memory.
I am not confused. You were trying to create a confusion by lying on national television that the government is trying to amend an act. There is no legislation in place. There is no legislation.
Well, Ayodhya is settled, and that is not the issue of contention. I want to ask Sushil Pandit. Sushil Pandit, amongst the many things which are objections by the petitioners, one of the objections is that this 1991 Places of Worship Act is applicable all over India except in Jammu and Kashmir. Now, on this alone, what about the legal standing of the Places of Worship Act? Apart from the other objections of the cut-off date, about the fact of civilizational questions of Kashi and Mathura, where do you think this is leading? And, you know, today we are here hearing Atikur Rahman Sahab as if, this cannot be done, this can't be done. Well, the Chief Justice of India has asked the government to submit its affidavit on the floor, with the Supreme Court of India. So what are we talking about? Who's going to determine the rights of the petitioner? Mr. Atikur Rahman or the Supreme Court?
Yes. Thank you, Navika, for having me on your show, and good evening to all your viewers and panelists. First of all, I was very happy to see some progress in this conversation when I heard Atikur Rahman say that there was bigotry of the medieval times, and earlier in the montage, Hanan Mullah said the crimes committed in the past. So thank God there is at least acknowledgement, because till now we have heard flat denials that nothing of this sort happened. At least there is some progress and some acceptance of guilt. That's number one. Number two, very interesting proposition by learned counsel Sanjay Hegde, who says what prevents government from making a law. I completely agree with him. The government of the day in 1991, in its wisdom, created a completely unjust, unreasonable and arbitrary law on a rebound after 1991 events that happened in Ayodhya. Are they constitutional? Are they valid? Do they infringe on the rights of others? Are they equitable? Now, these are the issues that courts have always examined with respect to other laws. And indeed, it's not my place to remind him that courts have set aside unjust laws in the past. I can give him examples. Father of Mr. Chandrachud, who's going to be our Chief Justice, himself had set aside one of the laws. He was one of the first ones to set aside the law with Bihar, which was about takeover of land, the Land Reforms Act in 1975. So legislators' right is not overriding. The courts have to sit in judgment over constitutionality. And if they hold something unconstitutional, they are within their rights to set aside those laws. And number 3 point, as far as this argument that please kindly give us Kashi and Mathura and then we will forsake all our claims, is completely bunkum. I don't know who gave this right to whoever, that my Kali temple in Srinagar, which is now called Khankai-e-Maula and also variously called Shah-e-Hamdan, is to be retrieved. My community worships on the outside wall at the banks of Vitasta, Jhelum. It is humiliation to worship at the steps, which is the boundary wall of Khankai-e-Maula, because we've been evicted from there. Likewise, Bhojshala. Who gave the right to give away Bhojshala? Who gave the right to give away Baba Budangiri? the shrine which is in Karnataka, on which there is a great deal of consternation. There are similarly various other extremely sacred sites which we need to retrieve. And we need to retrieve agitating our right as a peaceful community in this day and age where we are a constitutional republic. And it is the duty of the courts. They can't keep pushing the ball in government's court, in the legislature's court. Judiciary has to serve its own responsibility, and indeed governments and legislatures also. We cannot fire from each other's shoulders. We have to take our responsibility and set these things right. There is no time bar on injustices of the past. These are indeed civilizational issues. They are as relevant today as they were then.
Well, Majid Hydari, you want to respond? Sushil Pandit has many of his rights taken away in Kashmir. There are a few that he still wishes to fight for. Can you take away the right from him and people of his community?
Navika Saiba, this controversy reminds me of Baba Bulle Shah's famous couplet. It's in Punjabi, though every Indian cannot understand Punjabi, but I feel they understand the essence of his couplet. It says, Masjid thade, mandir thade jo kuch thenda. Ik bande da dil na thavi, Rabb dilam vich rehenda. The issue is not of places of worship act of 1991. The point is that BJP is trying to hypnotize a section of its vote bank through a perception that Hinduism is witnessing its renaissance since 2014. It's not about Astha. It's about vote bank politics, BJP's agenda of 2024. It has nothing to do with Astha, because otherwise, were Hindus not existing in the country for the last 70 years, or were my Hindu brothers not here for the last 30 years since when this law came into force? No, this is not about Astha. This is certainly not about that. It's only about vote bank. And then one more important point. This
my friend, before you proceed further, yes, Hindus existed, but do you know, calling yourself a Hindu was almost done apologetically in this country. and then Renaissance, or the pride that people are fighting for today is the pride that is important to them. So whether it is one political party or another, the question here is about the right of people of a certain community. Why would you want to take away that right? Hands are going up. Coming to you, Sanjay Hegde, but Ishkaran Bhandari first. Ishkaran Bhandari objecting.
Existence without rights, without dignity is violative of Article 21. We are supposed to be happy that Hindus exist. But let me just give you two examples. Afghanistan, Sanatan Dharam was 7 lakh in 1970s. Finished. Kashmir, where you will find much better statements by Sushil Panditji. What happened to Hindus and Sikhs in Kashmir? A genocide, a continuous genocide over the centuries, and a genocide done in the independent India. So let us please be very clear. We are not to be thankful that we exist and we get squeezed out. We have to exist, we have to flourish, and we have to reclaim what is ours, because injustice,
but Dariji, you are in a majority, you live in majority, you have been majority since the Muslim
My friend, there cannot be an argument which says, and Tehseen, I want to ask you, can there be an argument which says, अरे इतने सालों से तो तुमने claim नहीं किया, अब तुम्हारा कोई हक नहीं है claim करने का? What is this? I mean, is there a cut-off date? Is there a cut-off date when people can actually, raise their rights? Yes or no?
I am actually for the first time. Sanjay bhai, I'll just be very brief. I'm actually for the first time in agreement with Sushil Pandit bhai and even with you, ma'am. First time. And I'll tell you why. I think why this Kashi Mathura, as the other spokesperson, as the other panelist on your show said, I think we should go to every single issue. Why limited to the 16th century? I think we should go back 10th century, 8th century, 7th century, BCE, go before time. I am not against it. I think this is what India should do. I think rather than discussing how India can become an economic superpower and how we can empower our kids, I think we should go back. And I want to ask one question. I want to leave it for your audience to think before I end. Today, we are saying one community continuously. Obviously, the dog whistle or the cat call is that maybe Hindus have been discriminated. Then I take that with humility in front of you. May I ask, tomorrow if the Jain community says our temples were also demolished, say, by a Hindu king, then we go back into time there, say tomorrow the Hindu community thinks the Jain.
You know, of course, Jains can also fight. This is not a Hindu-only law. This is not a Hindu-only law. So why are you know, if you're talking about dog whistle of a particular kind, you know, why are you limiting it? Yes?
No, absolutely. Let's go back to 4th century, 3rd century. Please, I absolutely agree with you.
Well, Subrasha, respond to that argument.
I find this argument about economy. You know, I find this argument about economy that let us discuss this and not that because, you know, our economy is more important. Well, you know, with respect to every government or state government, we have so many different ministries and departments. It is not as if a woman and child development ministry is working, the finance ministry stops working. There's ministry, fine, there is a whole new sense of revival with respect to Ministry of Culture, but that doesn't mean Tehseen Poonawalla cannot go and lobby for whatever economic reforms he wants with the government. He can continue to do that. He shouldn't comment on civilizational concerns. He should stop coming to debates which discuss issues of culture and policy, polity. He should just focus on economic concerns, and I'm pretty sure there is a whole, you know, community out there with respect to India Economic Forum and all of that, which discuss only issues of economy. So things can go parallelly. Only if you want things to run, people who are really passionate about this cause are talking about it. And why just Jain community or a Buddhist community? Even Muslims, if they want, they can, start doing that. But they would not, because they have something called the Waqf board, which Hindus don't. You know, when partition happened and when Muslims came to this country, they had something called the Waqf board to actually take care of their properties. We Hindus did not have any board of that sort in Pakistan. Tomorrow we cannot go and claim our specific places of worship in Pakistan. So please understand that there are...
I'm running out of time. I'm running out of time. The last comment to Sanjay Hegde. I'm running out of time. Last comment to Sanjay Hegde.
See, the last comment is simply this. What Parliament has done, Parliament can undo. Parliament has the power. Do your job. Why get the courts involved? As far as constitutionality is concerned, all that is looked at is, number one, do you have the power? Number two, does it violate any fundamental rights? Number three, did you come in time? This is an act of 1991. It has stood for nearly, 30 odd years now. We keep changing our laws very frequently. Do your job, Parliament. Take your call.
Well, I'm sure the government is hearing you, and maybe they were just waiting for your encouragement. But having said that, may I just say that the power to decide on the constitutionality is also with the Supreme Court of India. Why can petitioners not exercise their right to challenge this very constitutionality? What is so sacrosanct about the Places of Worship Act of 1991 that you can't even question it in the Supreme Court? What happens is anybody's guess, or the bench that will hear the matter and decide. But just about questioning it, does it call for, lessons to be taught to the government on how they can change the laws? I'm sure governments of the day know their rights and their duties. We leave it at that. Thank you very much to all my panelists for joining me on debate number 1.